We have two cases on our oral argument calendar this morning. The first case is Logan Hunter Vagle versus State of Minnesota. Just a couple of housekeeping matters. Justice Hennessy is unable to be with us today, but she will be participating in both cases. With respect to this first case, just a reminder to counsel that you'll each have 3 minutes of uninterrupted time to make any opening statements that you'd care to make to the court. At the end of those 3 minutes, I will stop you if you haven't stopped yourselves, and to see if the court has any questions. Mr. Erickson, it looks like you've reserved 10 minutes for rebuttal. Is that correct? Okay. You may begin whenever you're prepared to do so.
Good morning, and may it please the court. My name is Anders Erickson, and I represent Mr. Vagle this morning. There is no doubt that gun violence is a serious problem in Minnesota, and the Minnesota legislature should continue to do whatever it can to address the policy questions surrounding gun violence through the legislative process. But the question before this court this morning is not a policy question about how to best curb gun violence. Instead, what this court must decide is what the legislature intended 30 years ago when it wrote the removal or alteration of a serial number statute. Did the legislature intend to create an outright ban on thousands of firearms, including privately made firearms and firearms manufactured prior to 1968? Did the legislature intend to expose law-abiding Minnesotans in possession of these firearms to felony charges and the resulting consequences, without providing any explanation for how to comply with the law or any grace period to comply with the law following the enactment? The simple answer to these questions is no, this is not what the legislature intended. Instead, the plain language of the statute, read in its proper context, clearly effectuates the known intent of the legislature, which was to create a state crime that mirrors the federal law prohibiting the removal or alteration of serial numbers. Importantly, it is telling that nowhere in the county attorney's brief or in the attorney general's amicus brief is there a single argument that this was not the legislature's intent when enacting the statute. Nonetheless, the state now argues that 30 years after the legislature wrote this statute, the legislature's use of a single quotation mark changes the entire purpose of the statute, bans thousands of firearms, and makes otherwise law-abiding Minnesotans felons. This plain language argument must be rejected. Alternatively, if the state's interpretation is deemed reasonable and the statute is therefore ambiguous, the canons of statutory interpretation and the legislative history, which the state has not argued against, leave no doubt regarding what the legislature intended in 1994. And when choosing between these two interpretations to resolve the ambiguity, our interpretation allows for a clear application of the law, alleviates constitutional vagueness problems, and avoids serious Second Amendment concerns that would surely result from an outright ban on certain firearms. In sum, this court should reject the state's interpretation of the statute because it is unreasonable, unworkable, conflicts with the plain language of the statute and the legislature's intent, creates serious constitutional concerns, and, as it has done in this case, creates absurd and damaging consequences for otherwise law-abiding Minnesotans. I'm happy to entertain the court's questions.
Counsel, I just want to clarify, you're not making any constitutional claim under the Second Amendment, correct?
Not a separate Second Amendment claim, but this court does need to consider the fact that it should not interpret a statute in a way that could result in a Second Amendment violation or conflicts with a constitutional amendment like the Second Amendment.
You never raised that argument at the trial court?
I was not the trial attorney, but no, that was not raised before the trial court, no.
Counsel, you jump immediately to what the legislature's intent, what you believe the legislature's intent was. But of course, we only get there if we find that the statute's language is ambiguous. And I actually, frankly, I think you have a meritorious argument, certainly, that if you were to look at what the legislature did, it sort of mirrors the statute. But as you well know, like, as I say, we don't get there unless we say the statute is ambiguous. And I'm still trying to figure out what is ambiguous about subpart 3, which makes it a crime to receive or possess a firearm that is not identified by a serial number. I don't know what's ambiguous about that. So you help me with that.
Yeah, absolutely, Your Honor. And I think the really important thing in this case is to read that provision in its proper context with the entire statute. Just reading that alone, if that was by itself, just subpart 3, there might be other vagueness issues and whatnot, but that alone would, that's pretty clear. But we have this federal provision which does all the work in the statute. And that federal provision within those quotation marks says serial number or other identification information that clearly connects that to all 3 subparts. When the legislature enacted the statute, I agree that wasn't the most artfully way of doing it, but if they wanted to connect all 3 of those subparts to federal law, they included those 2 different terms that are independent from each other because the legislature used or. There's no connection between them. So just because there's quotation marks around them doesn't mean that that only applies to subparts 1 and 2.
So, counsel, on that note, because the phrase is in quotation marks and it's not in subpart 3, if we agree with you, does that mess up, for lack of a better word, our other statutory interpretation tools?
No, Your Honor. Like I said, I think this statute is unique in how it was written, but I think this court can state that because both those terms are within the quotation marks, that therefore it applies to both phrases, serial number or other identification information. And that same provision states the section, right? So it's not just subparts 1, it's not just subpart 2. And the second thing we have to look at is when reading this in its entire context, subpart 3 doesn't make any sense without the federal law. There would be 2 different regulatory schemes between subparts A, B, and C. There would be the federal law applying for the first 2 and a law that I'm not sure what it would be. We don't know what the definition of serial number is. We don't know who could have put the serial number on the firearms. There's no sort of recording mechanism, and that's the whole point of serial numbers, is once a serial number is placed on a firearm, it needs to be recorded. So then if that firearm is found after a crime or is stolen, we know where that came from. But if we just have that on its own with no other regulatory scheme or no other statute describing anything about serial numbers in Minnesota, what are we going to do with that serial number? It's just going to be a number.
Counsel, I took a look at the criminal jury instruction that's proposed for this crime, 22.20, and it's interesting that in each of the 3 subparts, the reporter has the following statement: a, quote, serial number or, quote, other identification, quote, means the serial number or other information required under federal law for the identification of firearms. Now, obviously, that's a reporter's assessment of what the law means, but that seems to be consistent with your argument that the words serial number apply to the federal law definition applies to each of these 3 subdivisions. Is that kind of what you're arguing, that we can't take that word out of that context of the entire phrase?
Sorry if we could go back. So you're saying the jury instruction guide said that federal law applied to all 3 subparts?
It appears to say that. It says required under federal law for the identification of firearms, and it doesn't have the phrase, the entire phrase in quotes.
That's right.
It isolates serial number, quote unquote, and other identification, quote unquote. Now, I realize as far as statutory interpretation tools, the crim jigs aren't going to, we have to get the law right, but I thought it was interesting that the district courts around the state are being told that that's the meaning of this provision. That's
right, and I think that also plays out in the history of the charging and how few charges were under subpart 3 prior to like the last 2 or 3 years, and that nobody believed that firearms manufactured before 1968 without serial numbers were a crime, right? That there were no prosecutions in Minnesota for someone who possessed a .22 caliber rifle or other long guns that were manufactured before 1968 without a serial number. And if this court adopts the state's interpretation, every single one of those would be a felony. And in 1994, I assume it would have been a pretty big deal if the legislature passed a law saying that every one of those firearms creates a felony and would create then an outright ban on those firearms with no ability of those individuals to know how to comply with the law. Where were they supposed to go to get a serial number? Could they just write any number on their firearm manufactured before 1968? There was no explanation at all as what individuals were supposed to do.
So under your analysis and incorporating the federal law in subpart 3, what is your answer to the question that you just posed? What in 1994, if you had a long gun that didn't have a serial number, what was the procedure under federal law?
There was no federal serial number requirement for a firearm before 1968 that didn't have a serial number.
So you would interpret it to mean subpart 3 would mean you don't need a serial number, even though the law says you do need a serial number?
No, I read it as the federal law articulates it, where you only need a serial number if it's required. So the federal law says you only need a serial number if it's required by this chapter. The way the Minnesota legislature wrote that was instead of having it after every subpart, which wouldn't have made sense because it couldn't say under this chapter, it had to say under federal law, it did it at the end. So under federal law, no one was required to put a serial number on a firearm manufactured before 1968, under federal law in 1994. So the Minnesota legislature passes that law, it comes into play, it clearly states that federal law applies, so nobody goes out and turns over their firearms to law enforcement. In fact, law enforcement is still selling these in auctions all across the state of Minnesota, because even without serial numbers.
But you've got to agree it would be a pretty unusual way for the legislature to proceed to write a law that says it is illegal to possess a firearm without a serial number, period, and then incorporate by reference federal law that says you don't need a serial number on certain firearms. I mean, I think that's your argument, and I understand why it is your argument, but like, what's your argument then for why the legislature would have proceeded in that way?
Because it was attempting to adopt the federal law that prohibited removing serial numbers from firearms. So it incorporated federal law by referencing it, and then once somebody would look at the Minnesota statute, then they'd look to federal law and say, is this firearm required to have a serial number? Because if it wasn't required to have a serial number and someone put one on it, scratched off, that's not a crime either.
But but then that theory is you're adding a lot of words to that subpart 3. Subpart 3 doesn't say it's illegal to possess a firearm without that is required to have a serial number. It just says it's illegal to possess a firearm that doesn't have a serial number, right?
So I'm not adding any words to the statute. The federal requirement in 609.667 refers to what is required by federal law. It is not let's look to the definitions in federal law.
So it's a serial number that has to, if a gun has to have a serial number under federal law, then it has to have a serial number for purposes of this statute.
That's right. And then also within subparts 1 and 2, only firearms that are required to have serial numbers, it's a crime to scratch them off.
So, and I read through that Fed reg that you cited.
It's a fun read, huh?
Well, I skimmed through it, but I found the places that you were pointing to. But what I didn't understand exactly is what's the statutory argument under federal law that it's limited, that it doesn't go back before 1968. Is there a piece of federal statute that actually, I mean, I get that that's how it's been interpreted, at least by the AT or whoever did this regulation. But what is it in federal law that says it only goes back to 19? Is it because it's manufacturers? It's limited to firearms that were produced, I guess, by manufacturer, and you can't say that they had to do it before it was a law?
Yeah, let me see if I can try to clarify, and then I can respond to any questions. So in 1934, Congress passed the National Firearms Act, and it required serial numbers on a handful of types of firearms, like machine guns and other very specific crimes. It did not require serial numbers on .22 caliber rifles or shotguns. Then in 1968, the Gun Control Act was enacted, where it required serial numbers on every firearm, including the .22 caliber and shotguns. But it grandfathered in this idea that any firearm manufactured before 1968 that was not required to have a serial number we're not requiring you to add one. So there's this.
And is there language in the statute that says that, or is that just how it's been interpreted? I'm sorry.
No, it's okay. It's in, you ready for it?
Yes.
This is a section 177.50. It was enacted in January 18th, 1958. It's a Title 26 regulation.
So
This
was
is an
not part
ATF
of-
regulation.
So that was not part of either one, but it created this grandfathering principle.
Yeah, so what happened in both the National Firearms Act and the Gun Control Act is a delegated power to the Attorney General and then delegated power to the ATF. And then they create all these regulations.
Counsel, what I'm confused about, though, is why we're even looking at or why we're even concerned with anything that happened in pre-1968, because you're making an as-applied challenge as applied to your client. And it doesn't seem to me that, well, there is nothing in the record. In fact, the record is just the opposite. The Glock that your client possessed was not manufactured in 1968. He put it together himself somewhere around 2021. So I'm trying to figure out how we ever even get to what happened pre-1968. That's not before us.
That's right. So two responses. One, it's not an as-applied challenge when we're talking about whether this is a crime or not, right? 99% of my argument today is this is not a crime under Minnesota law to possess a privately made firearm without a serial number. That part of the argument has nothing to do with 1968. Privately made firearms, homemade firearms, have never required serial numbers in the history of our country.
Well, I thought part of where you started, though, was that if we were to adopt the state's position, you had sort of this parade of horribles, and I'm not minimizing that. Those are serious concerns. But one of those concerns was we would be criminalizing folks who had these kind of weapons from pre-1968. So that's what I'm getting at, that why are we concerned about that?
Yeah, so if I could just make clear that this is a statutory interpretation argument regarding whether this is a crime.
Right.
Let's take the constitutional part completely out of this. Looking at the plain language, if this court says every firearm in Minnesota is required to have a serial number, then everyone who's in possession of a firearm that was manufactured before 1968 that does not have a serial number is committing a felony.
Okay.
And there's no distinction between a privately made firearm and a rifle made in 1966.
Okay.
And there's no way under the plain language to make that distinction. So if that would be the parade of horribles. And again, I want to make clear that this isn't just as applied to my client. This is whether 609.667 requires serial numbers.
Okay. That's helpful. Thank you.
And as far as I think where we started the discussion was whether this was ambiguous or not. And part of that analysis, you have to have two reasonable interpretations. And our position is the state's interpretation is not reasonable. One, because of those consequences, and because there's no way that the legislature intended that in 1994. And that's what we're doing here, is we are trying to figure out what was the legislature's intent. I understand the quotation marks are the one thing that we're looking at to try to figure out what that means. But again, I really am strongly about it that the legislature wanted to include those two provisions within that quotation set and put an or between them to make sure that they're independent from each other. These are not two things that have anything to do with each other, and it doesn't make any sense if you take it out of the context of why they would want just those two to always be together, and they only apply where it was those two together in the statute. Then as far as ambiguity goes, if we get to that point, like I said, the state hasn't made any argument in their brief, and amicus hasn't either, that once we get to ambiguity, any sort of legislative intent supports their position. And I think that's very telling that the state of Minnesota right now is advocating for something that we all can agree that the legislature didn't intend. And those consequences, like I mentioned before, would result in possible Second Amendment challenges in the future, and this court should interpret it in a way that does not then create a Second Amendment issue. I agree that this was not raised below, but the specific Second Amendment issue, but this court can interpret it in a way that would then result in that litigation.
Counsel, I wanted to go back to the plain language. So if it incorporates federal law, are you arguing that it also incorporates the ATF regulation?
I am, Your Honor.
Do you have authority for that? I don't know if we've ever done that before with a federal regulation. And the second part of my question is, assuming that I'm dubious about that, then what would we be incorporating from the actual statute?
Yeah. So I think, and one thing that was mentioned in the amicus brief was cases that this court has decided where they've referred to definitions in federal law, and then you don't go to regulation just from that definition. So if the Minnesota law says, look to federal definition of this word, I agree, we just look to that word. But that's not what the statute's doing. This statute is stating that what is required by federal law regarding serial numbers or other identification information. So in order to understand what's required by federal law, we need to go into the actual regulations that were written by the ATF and the Attorney General. Because just within the plain language of the federal statute, we don't get into any of that. I mean, the plain language of the statute is talking about the Secretary of the Treasury. They have nothing to do with this anymore. That power has been delegated from the Treasury to the Attorney General and then the ATF.
But that last line, as I read it, it reads just like the legislature defines terms in a statute. As used in this section, quote, defined term means, like, it looks to me like they're defining a term. So what's the argument that it's more than a definition?
You're talking about in 609.667?
Yeah.
So if you go onto that federal, where it says what is required by federal law.
But it's defining serial number and other identification, right? As used in this section, that term means. So that, I mean, so you were making the argument that this is something other than a definition, but it reads just like the legislature defines terms all the times in statutes. So your argument is the language that follows is because it says required, that it takes it out of that and it means that we are encompassing a whole federal regulatory scheme?
That's right. Because there is no Minnesota regulatory scheme.
Well,
and under subpart...
Is there a federal definition of serial number?
There's not a federal, the ATF...
Or other information?
Yeah, so, well, the ATF has very specific guidelines.
But is there a statutory definition? Are those defined in statute?
No, it is a regulatory scheme. The 27 CFR 478.92 is the ATF's definition of what is required under federal law for a serial number.
I'm just saying you couldn't look to the federal statute for that definition because it doesn't exist.
No, that's correct. And like I said before, do you have a...
So,
And that going back, that was part of my question. If we just look at the federal statute, what would we be incorporating?
Everything. I mean, there's the federal statute.
I thought you told us that the federal statute just banned every firearm, including 22 shotguns, except for those before 1968.
No, that's not correct. The federal law does not require serial numbers for any privately made firearm, period.
Does it talk about privately made firearms?
The federal statute does not, but again...
See, it's a whole new deal.
So the
This
Minnesota...
is a whole new category of firearms that's come into being after the federal law.
That is not correct, Your Honor. When we're talking about privately made firearms, there's no difference between... So what you're talking about is the modern firearm that you can, parts of that you can buy online and you can put them together, and that's a huge problem. Our legislature needs to do something about that and articulate clear regulations, just like the California legislature has done recently, the Connecticut legislature has done recently, to ban those types of firearms if that's what they want to do. But to take a statute like this that had nothing to do in 1994 with what we're talking about, when federal law did not require serial numbers on privately made firearms, whether it's a hobbyist making a firearm in their basement.
But is it silent on that issue, or does it say something specifically that you can point to draw that conclusion?
In the Minnesota statute?
And the federal?
Every ATF regulation has said privately made firearms are not required to have serial numbers. So that's what everyone in America has relied on when they're buying these parts, when they're in their basement with their grandparents building these firearms. That is what they've looked at. And now this new interpretation of the law within the last couple of years has made them all felons. And there's no difference between pre-1968 rifles and a privately made firearm and a firearm kit that you buy online. And right now what the legislature needs to do is distinguish between those, not make it a firearm to possess not make it a felony to possess a firearm before 1968 without a serial number, but specifically regulate these ghost guns that are a problem. And to take a 1994 statute and then try to encompass all of that into it is going to create huge problems. And again, if this court agrees with the state, there's no way to distinguish between those firearms made at home, or these kits that are coming in, and that's what the legislature needs to do.
So where in the federal regs are post-1968 ghost guns covered in the sort of privately made category?
So if you read the new rule, which Justice Thiessen and I were discussing, it articulates that numerous times that the ATF, that the Attorney General has never required serial numbers.
And when was that part of the reg promulgated? Was that at the same time as the pre-1968 regs?
So this was in 2022.
Okay, so we have some federal regs that predate 1994 passage, and your argument is that the legislature must have had those in mind when they were passing the law in 1994, and then we have other regs that are post-1994, and you think we should count those all as part of the incorporation here?
A couple things, and I just want to be clear. There is not a single reg that has ever said that a serial number is required on a privately made
Well, we have the statute, though. Like, I don't, on the plain face of the federal statute, you're not arguing that the statute gets at pre-1968 or ghost guns, are you?
No, what the statute is what is required under federal law. So the federal statute only requires serial numbers, which is required by federal law. I get that there's a lot of steps, and hey, I wish the legislature would have done something different in 1994. I don't think, well, if you listen to the legislative history about this, privately made firearms were mentioned, and they did not state, they could have clearly said, it is a felony to possess a privately made firearm, even though they're not required to have serial numbers, but they didn't do that. They didn't do anything like that. The statute was only for removal of serial numbers from firearms.
Thank you, counsel. You'll have time for rebuttal. Ms. Kelly.
May it please the court, counsel, I'm Kelsey Kelly and I represent the state of Minnesota in this matter. Minnesota statute section 609.667 parent 3 is clear and unambiguous. It states that anyone who receives or possesses a firearm that is not identified by a serial number is guilty of a crime. It is not void for vagueness because anyone who reads that knows what is prohibited in the state of Minnesota. Minnesota law is more restrictive on this point than federal law. First, I'd like to talk about what a ghost gun is. There are two different ways in the modern era ghost guns come to be. First is through a 3D printer where you would print a receiver and a frame, and you would come up with the other parts and put it together. The proper way to go about getting a serial number would be to contact the ATF to go through a process of applying it. And then before you drill a hole in the receiver that allows the trigger in the firing pin to work, you apply the serial number that you got from the ATF. Before you drill that hole, it is not a firearm under Minnesota law because it is totally inoperable. The other way it works is you can get a package in the mail without that hole that I just described. So it comes in the mail, and the reason why it's lawful to receive them in the mail in Minnesota is because it doesn't have that hole and it's totally inoperable. And with any drill, you can drill a hole in that package and create an operable firearm. That's when it becomes a firearm because the triggering mechanism and the firing pin are all operable after that. Before you drill that hole and put it together, you need to, again, contact the ATF, get a proper serial number and put it on it, and then drill the hole, and then you have your lawful firearm. The statute and the process to get a serial number, getting the serial number, it might be confusing. If it's confusing to you, you should not possess one of those firearms. You should go to any retailer and lawfully buy a firearm that has the serial number on it, and the manufacturer has already done that work for you. The statute is clear and unambiguous. It was even admitted by the district court in the district court's order that the statute clearly prohibited the possession of any firearm without a serial number. The Minnesota statute does not mirror or incorporate federal law. In fact, Justice Procaccini, you brought up the fact that the part at the end of that statute, in quotations, serial number or other identification means, and then it goes on, and the only two places that exact quotation exists is in paren 1 and 2. That is significant. That is not in paren 3, which this case involves. It is true under federal law that privately made firearms or ghost guns are not illegal, but in Minnesota they are, until you get a serial number put on it properly. I'm ready to entertain the court's questions.
Counsel, describe for me what each of the subparts are designed, who each of the subparts are designed to punish. In other words, it seems to me there's something different going on in subparts 1 and 2 than there is in subpart 3, in the sense that subparts 1 and 2 list a whole host of things that are there. So tell me what's designed to, what is it trying to get at?
Yes, Your Honor, in subpart 1, that is to criminalize the person who is actively damaging a serial number that's already on a firearm lawfully. So if you're going through and you are in some way changing, amending, or doing anything to change that serial number, you are guilty under that offense. Then under paren 3, if you receive, so if the person who...
No, you skipped number 2. What's happening in number 2?
Oh, yeah, sorry. In number 2, it's about receiving, sorry, Your Honor. So that's essentially receiving that firearm that has already been manipulated. The serial number has been manipulated unlawfully in some way if you receive it. And then number 3 is much more broad. And it does include firearms before 1968. Minnesota has a different definition of firearm than federal law. Any firearm under Minnesota law without a valid serial number is criminalized under paren 3.
Is a gun that has, is a firearm that has the serial number obliterated or removed, does that firearm have a serial number?
It has a serial number that's been manipulated, yes. So I would charge that under subpart 1 or subpart 2, depending on the facts of my case.
I'm talking about possession. So if it's obliterated, it still has a serial number?
That's right. And those are very different.
How is that?
So when those cases come in for charging, you can see on the firearm the way...
No, I'm sure, I get what obliterated means.
Yeah.
And removed.
Yes.
Removed would mean something more than obliterated, like it's gone. Mm-hmm. And you're saying nonetheless, it still has a serial number?
I think although the serial number, you can't see it on there, it's not on there, that firearm once did have a serial number, so that's kind of the distinction I'm trying to make. I think paren 3 is talking about firearms that never had a serial number.
Well, that doesn't seem to, well, okay. But
So
why would you need obliterated or why would you need removed? Why would you need that part of 2 if your provision is correct, if your interpretation is correct? I mean, it seems to me if the serial number is removed, that gun doesn't have a serial number.
You're right. It no longer has a serial number that law enforcement can identify it by, but it did have one at one time, is what I'm trying to say. So the thing is, technically through ballistics, you can also, if a gun is used in multiple events and at one time we knew its serial number and we can match it ballistically, you would actually be able to say, well, this gun's serial number is XYZ. We know this because it was previously used in this crime when we know it had this serial number. So factually, the way they come into it to us is different.
And can I also ask you, you talked about our definition of firearm,
Mm-hmm.
and in your opening statement you said, well, it's inoperable, even though you have all the parts.
Mm-hmm.
But I thought we've held that even an inoperable gun that you have all the parts is still a firearm. So I don't get that argument.
So this court has held that. The way those packages...
So that would seem like if you're receiving the parts, you're committing a crime under Stone and a whole bunch of our cases.
So if you are receiving all of the parts, I agree with you. But the way these packages come, oftentimes you have to also buy other parts to put inside them from other firearms. So you actually have guns out there that are ghost guns that are made from different, like 3 or 4 types of guns where someone has put them.
But at some point you're going to have all those parts together.
Yep.
And even though the hole is not drilled, so you can order, can you get a serial number for a gun where you haven't gotten the parts yet?
No.
Okay, so then, once you receive those parts, while you're holding those parts, before the hole is drilled, you're committing a felony. Because in Minnesota, that's still a firearm because it's an inoperable.
If you have all of the parts,
Well,
yes.
not even necessarily all the parts, it's
Well,
held in stone.
Yes. However, obviously, we have prosecutorial discretion, and that actually also.
Well, okay.
I have a question, Counsel, as it relates to, are you aware of any instances in Minnesota where an individual has been charged with possession of a gun pre-1968 that does not possess a serial number? Because as I understand your argument, you're saying that anybody who does own those or possess those is committing a crime, and I'm not so sure that Minnesotans know that or would agree with you.
I am not personally aware of any prosecutions involving guns made before 1968 or very old guns without serial numbers. You have to keep in mind, I only work in Anoka County. I've only worked there for 10 years. So, and I have not gone through the district courts to find out anything about that. However, and I think you're right that some people might not realize that. But yes, they are illegal. And there is a way to get a serial number even for those older guns if someone wanted to get a serial number for an older gun. However, the reason why these prosecutions are increasing is because of ghost guns and what I was talking about with prosecutorial discretion.
Right, and I think that goes to your opponent's point, is that the ghost guns, this new category of guns, is concerning, but the legislature hasn't really done anything about that. Rather than sweeping in all of these pre-1968 guns, which I would agree with him, it's different.
Your Honor, the legislature hasn't done anything because the statute already criminalizes them. They are firearms under Minnesota law, and a statute clearly and unambiguously says that they are prohibited without a serial number. The legislature does not need to act because it is already illegal, and they are relying on the prosecutorial discretion of the executive branch to protect public safety, and that's what we're doing.
So I know that the constitutional question isn't explicitly before us, and we're not ruling on that, but the other side says that we should at least look to that, the Second Amendment, as if we think this is an ambiguous statute, we should look to the Second Amendment to sort of constitutional avoidance, because we'd be creating a constitutional issue if we rule in the way that you're arguing. What's your response to that question?
Your Honor, I'd ask you to look at my brief to the Court of Appeals before it was clear or not whether we were litigating the Second Amendment. And in that, I made quite a few arguments that go all the way back to Virginia in the 1600s that required serial numbers on firearms for taxation issues. So clearly, even before we were a country, we were putting serial numbers on firearms for the purpose of taxation and regulation. Also, this statute does not prohibit any type of gun, no caliber of weapon, it doesn't prohibit whether it's a handgun, a long gun. You can still go and get any type of gun you want at a store, and you can even make one as long as you go to the ATF and get the serial number. So there is no class of weapon that is actually criminalized by this statute. And so that's also part of the Second Amendment analysis. And I did do a brief version of that at the Court of Appeals, but I didn't do that here.
Is it just, as we explore this a little bit more under the Second Amendment, is there any distinction between a law that would criminalize the pre-1968 unserialized guns and the more recent ghost guns that people are putting together? Like, is the Second Amendment analysis with respect to those two categories of firearms?
No, because this is talking about the serial number. And so that's why it's not a Second Amendment issue, because we're not talking about a class of any type of weapon, and our country has a long history of requiring the serial number. So that's why it's not a Second Amendment issue. We're talking about the serial number, not the type of gun or firearm.
So, counsel, if your opponent's correct that the phrase serial number incorporates the serial number, other information required under federal law for the identification of firearms, if the interpretation of the statute that he's urging us to adopt, if we agree with that, then under the federal law, as I understand it, a privately made firearm or a ghost gun is not required to have a serial number on it. Is that correct?
Under federal law, at this time, privately made firearms are not required to have a serial number under federal law. You are right.
So I asked your opponent this question, I'll ask you. The crim jig on this question says serial number means a serial number or other information required under federal law for the identification of firearms. Now, obviously, that's not a conclusive final statement on the interpretation of a statute, but isn't that a little concerning in terms of what a widely respected reporter on criminal law is advising district courts that phrase means? I mean, that seems like that should be something here. Maybe not. Tell me why I'm wrong.
Yeah, Your Honor, I think the jigs are something that district court judges often look to in order to prepare their jury instructions, but they are not the law. So you might look to them, but you have to always first go to the statute. So anyone in the district court's position, if something contradicts a statute and it's in the jig, it is the district court's job to fix the jig to match the law, not to match the law to the jig. So even though the jig says that, and someone may have believed that when they were writing that, and I agree, when I'm prosecuting, I use the jigs all the time because I do respect those people. But we actually have had several cases in Minnesota where this court has even said that the jigs are wrong, and the jigs are wrong.
Counsel, could you address Mr. Erickson's point that when we look at the language that's in quotation marks, serial number or other identification, that we have to give, as I understand his argument, we have to give weight to the disjunctive or, and so given that subpart 3 just has serial number, it's all part of the same thing, and so therefore the federal law applies. Why isn't that correct?
So, Your Honor, because that whole phrase, serial number or other identification, is in a quotation, I view that as applying to subpart 1 and 2, because if they wanted it to apply to subpart 3, they could have done serial number, end quote, or, quote, other identification to make it apply to all 3 subparts. So the way it's written, it also doesn't align with other ways this court has applied statutory interpretation to other cases. So we know that quotation, because it's in full, applies to the other places in the statute where it appears in full. They could have broken it up.
What do you say? And thank you, that's very helpful. There is something about this, though, when you look at the legislative history, you know, it just pairs up, you know, almost, the federal law pairs up almost identically. And there's a feel to this that maybe we're putting form over substance in terms of what the legislature really intended to do. And that's always our sort of guiding star, is we need to follow and to attempt to make good on the legislative intent. What do you say to that?
Your Honor, we only get to legislative intent if it's an unambiguous statute, and it is so unambiguous and clear that we should not be looking into that. I agree with you. When this statute was created in 1994, we were not talking about 3D printers. We were not talking about these privately manufactured packages coming in the mail for people to assemble and do drilling. No one was talking about that. I agree. That's something that's come up in the last 5 to 10 years. However, because the language is unambiguous, we need to look at the clear language of that statute and first look to that to see what the legislative intent is before we actually start looking at legislative history.
If we decide that the statute's ambiguous, that both of your arguments are reasonable readings of them, how do we come out? What's your best argument that we should still come out your way? Or do you agree that once we get there, then your opponent is correct?
Even if we partially had to incorporate some of federal law, I think that we would still win, because I think it's possible under another reasonable interpretation that you would have to look to the federal statutes and regulations to determine how to obtain a serial number. But because Minnesota has decided to be more restrictive,
well, what about just the legislative history, which we could get to in ambiguity, where they said basically it seems to me, listening to that committee hearing, the author and the committee was understanding that to be, we have this federal law, the federal government can prosecute it, but we can't as a state. And so we want to give power to county attorneys to prosecute what's already criminalized under federal law. That seems to be, what do you do with that?
You know, I do think that the legislative history supports that. The problem in the way is the clear and unambiguous language of the statute.
Yeah,
Okay.
I get that, but if we get to ambiguity, so you say if we get to ambiguity, one of the things is there might be a reasonable reading that you have to incorporate one little part of federal law, which is the process for getting a serial
Yes.
number, but nothing else?
Right, because at the time, federal law also did not contemplate ghost guns. So it's not just Minnesota, nobody was contemplating the way modern ghost guns are working.
Is that the question, though, or is the question whether, I agree, probably no one was contemplating this maybe at either time, but to be criminal, they had to actually make something criminal. So it seems like you're proceeding from a presumption that because they didn't know about it, they should be put in the criminalized bucket. Although it seems to me, although I still don't see what the statutory, aside from the regulations, I guess, but that guns before 1968 and privately made firearms, I mean, this Federal Register seems to say that's always been the law. We're not criminalized. So if we're incorporating federal law, why does it matter that ghost guns weren't kind of in anybody's conception when it was also clear that privately made guns, firearms, were not criminalized in 1968?
So you're asking me why it matters that...
I mean, your argument seems to be, well, no one knew about ghost guns back then, so we should just we should read this to criminalize them. And I get your plain language stuff,
Yes.
but if we get to ambiguity and looking at what the federal government was doing, why would you think that it criminalized ghost guns when it pretty clearly, everybody agrees that it didn't? Privately manufactured guns.
Okay, so I'm trying to understand. So the criminal statutes actually the criminal statute is different than what we have in Minnesota law to begin with, because it actually goes through and talks about the different types of guns and the different parts of guns and what's criminal, what is a firearm. So already we are in a different ballpark from state law, because our state never incorporated that interpretation of what a firearm is.
Well,
So-
but I'm not sure, does that matter? I think what we're trying to understand is on which type of firearms does a serial number have to go on? We're trying to understand what serial number means. It's not defined anywhere. And so the only way we can understand what serial number means, if we are incorporating federal law, is to look at the federal statute, maybe the federal regulation. I guess we have to look there because the federal statute doesn't really talk about it, and determine which firearms required a serial number. If it didn't require a serial number under federal law, then it's not a serial number required under federal law. Why is that? Why? I don't understand how you can make something that federal law didn't require a serial number to be a serial number when the statute says, assuming that we're breaking up the quotations, a serial number required under the federal code.
Okay, so my answer to that is still similar. The definition of firearm in Minnesota is different than the definition under federal law, and that's why we are kind of diverged here, is because under federal law, the PMFs were never actually under the definitions in the federal code. So I'm saying if the statute is unambiguous, in Minnesota, any firearm under Minnesota law would still need to obtain a serial number under federal law. The ATF regulates putting out serial numbers, giving people serial numbers. So that's how you would go and get a serial number if you wanted one. What I'm saying is, under Minnesota, our definition of firearm has always been different than federal law. The reason why it's not criminal under the federal code is because they did not include that in their definitions, and Minnesota has always been broader than the federal law about what a firearm is.
Did not include what under their definitions?
In the federal code?
Yes.
The PMFs.
So, counsel, you're agreeing that if we get to ambiguity and if we decide we have to apply federal law, we don't just apply federal statute, but are you agreeing that it also incorporates the 2022 ATF regulation?
I don't think the statute would be incorporating those regulations, because those can change, and that's totally a different administrative procedure that I do not specialize in. So no, I don't think we would go as far as to say all of that is incorporated. Those are regulations. They're not even law, really. They're administrative law in a way, but they're not legislation.
You're also saying under the statute, under the federal statute, under federal law, so under the federal statute, privately made firearms don't require a serial number.
That's right, they are not listed, and federal law has always had a different definition of firearm than Minnesota has. That's what I'm trying to explain.
Counsel, let me ask it a different way that'll help me understand it better. How do you win? Under what theory do you prevail if we accept Mr. Erickson's argument that the federal law is incorporated? How do you win? How do you still prevail? So we're in ambiguity land, and we're looking at the federal statute. How does the state prevail? What's the argument? What's the syllabus point under which that you would say the state still prevails?
So, Your Honor, I would ask the court to apply Minnesota's definition of firearm under State v. Stone, and then if I were conceding that, you would then have to apply maybe federal law as it applies to how to get a serial number on a firearm.
Okay.
So another way of framing, it sounds like what you're saying is your opponent is asking us to incorporate federal law, not just as to serial number, but also as to the definition of firearm. And
Yes, he has to win. That's the only way he can win.
Okay,
Yes.
and does that go for, just to make sure I fully understand your argument, does that go for subparts 1 and 2 too? That the definition of firearm in those subparts 2 is Minnesota law, and we shouldn't be looking to federal law on the definition of firearm at any point in the 609, 667? Because it does get a little funky, right? If you look at those two subparts, it feels to me like maybe we should be looking at federal firearms.
I think there is a good argument to be made that subparts 1 and 2 incorporate federal law to a much higher degree than subpart 3 because of that last section with the quotation that I already addressed. However, the state didn't proceed under that subpart. I think the court should narrowly look at what is in front of it today.
Counsel, for an ambiguity, what is the effect of the legislature's efforts to ban ghost guns that was introduced in the 2023 legislative session but wasn't enacted? Is that a clue in terms of what the legislature thinks these laws mean?
I definitely think it's a clue. There have been challenges all over the state to this statute, which I'm sure the court is aware of. The Minnesota County Attorneys Association has gotten together. We know there have been numerous challenges all across the state, and I do think the legislature is trying to make it easier for prosecutors so that we're not using our resources in places like this to fight it out, and we can go back and do our jobs and work with law enforcement and protect public safety. So I do think the legislature is trying to help us out with that.
Thank you.
Counsel, but I think I also heard you say before that the legislature doesn't need to change the law because of the way you're interpreting it.
Your Honor, I don't think it needs to.
But
I think.
Sorry, you go ahead.
Thank you, Your Honor. I don't think that the legislature needs to, and in fact, the results of this case may also send a message to the legislature, and then it doesn't have to spend its time on doing that. However, the legislature is aware that prosecutors across the state are spending a lot of resources litigating this issue, and I do think that they're trying to make it more clear to defendants and defense attorneys so that we don't have to do that.
Thank you, counsel.
Thank you.
Mr. Erickson, you've got 10 minutes for rebuttal.
Thank you. And if I could just get back to what Justice Procaccini and I were talking about before. So if you look at how it references Section 5842, and then we go to 5842 and you go to B, and that title is Firearms Without Serial Number. It says you shall identify the firearm with a serial number assigned by the Secretary and any other information the Secretary may, by regulations, prescribe. That is not a blanket requirement for serial numbers. That is a requirement to do what the Secretary requires regarding serial numbers. And it's no longer the Secretary, then it went to the Attorney General, and then the ATF. So it's not just a definition of serial number that we can just take out of the federal statute. You have to read that provision in the federal statute as giving authority to the Secretary to prescribe what exactly the regulation is. It's a long way of getting to what the requirement is, but that's what the legislature did. And that applies to both A, B, and C.
Can you respond to whether we should consider Minnesota's definition of firearm versus the federal in interpreting the word serial number?
Yeah, so again, if you, 609.667 is using the section serial number or other identification. It doesn't say the definition of firearms from federal law. What we're talking about is serial number requirements. And as we know, the definition of firearm has changed in Minnesota after Stone. And if the legislature wants to use what this court did in Stone to write a new law, they should do that. But there's no way to parse out our definition. I mean, Minnesota's definition of firearm applies in the sense that if you have a firearm under Minnesota law, that's the same definition. But as far as serial number requirements, that has to be under the federal law.
Because it is trying to understand what type of firearms a serial number has to go on.
That's correct. And privately made firearms have never required serial numbers. And this idea that all of a sudden we have this new, that privately made firearms or ghost guns, as we're calling them, are new, that's just incorrect. The only definition of ghost gun is just a firearm without a serial number. So a firearm made at home in 1800 is technically a ghost gun. If the legislature wants to ban kits that are sent to people and they can put together, they can try to do that. But when we're talking about privately made firearms and ghost guns right now, we are talking about the exact same thing.
So what's your best argument against this basic notion that what the way we should read this statute is to look to the Minnesota definition of firearm and then to federal law only with regard to process and procedure? So we say all firearms in Minnesota need the serial number, and we only look to federal law to determine the process and procedure for getting a serial number. And federal law and regulations provide a process for obtaining a serial number. There's some internal logic to that argument.
I think that would be an absolute mess because federal law, nowhere in federal law does it say that an individual has to bring their firearm to get a serial number.
But it allows anybody. Am I right that it allows anybody to go get a serial number?
If I have a pre-1968 shotgun and I bring it to a gunsmith or a licensed dealer, I can request that they put it on that. But this idea that there would be any requirement and it would be clear to Minnesotans who have these guns.
Well, just to be clear, I mean, I heard Ms. Kelly say that you can go to ATF and request a serial number for a firearm that doesn't have one. Is that incorrect?
I don't see that in Minnesota law.
Under federal law, because again, I think the argument we just heard was that look to the definition of firearm in Minnesota, it's broader than federal law, but then follow the federal requirements for getting a serial number. And so, is there some obstacle to getting a serial number for a firearm if a Minnesotan wants to get one?
So you're saying, sure, an individual could go to the ATF and say, I want a serial number for my firearm. But if there's no requirement to do that in the law, and it's not anywhere in federal or Minnesota law that the person needs to do that, that's where the problem is. Someone gets charged.
Well, I think the state is arguing that subpart 3 creates that requirement.
I don't know where it says that, or where it says you need to go to the ATF to go get a serial number.
Well, it says it's a crime to possess or receive a firearm that is not identified by a serial number. So that means you got to have a serial number.
Right. So, again, it's what's required by federal law. Those firearms aren't required to have it by federal law. And second, what is, when the legislature wrote this in 1994, was there any grace period? If you get caught on the way to the ATF, are you committing a felony under Minnesota law? If you have it if you bring it into the gun dealer, are they going to report you for having it? I mean,
I know
there's
you might roll your eyes at this, but at some level, we do have to rely on prosecutorial discretion. I mean, I think there's certain things that are just, very unlikely to be charged. That's not this case, where, the defendant's in a rollover accident and there's the Glock 9, in the car that has no serial number.
That's right, and I see a huge problem, as the state even articulated. We're not going to prosecute rifles manufactured pre-1968 that don't have serial numbers. We're just going to prosecute these handguns. There's a pretty big discrepancy there between different parts of the state of Minnesota, and who that would apply to.
We should not leave it up to the prosecutors.
As much as I respect our prosecutors, I think that is a very clear problem. especially if they articulate that this morning, that, oh, we're not going to do it for certain guns, but we're going to do it for others. I have clients with all of these guns.
Because,
and
for example, if my mom has a shotgun pre-1968,
they're going to go after her.
you're going to go after her, or if it's used in, my brother takes it, he gets angry at somebody, shoots them, they could go back and say, well, you didn't have it identified, et cetera. I mean, I can see the parade of horribles that you're thinking about because I'm thinking about Northwest Minnesota where I'm from.
That's right. And anecdotally, I live in Minneapolis, but I've been getting calls and emails from people all across the state asking me after the Court of Appeals opinion, what do I do? What am I supposed to do with this? Am I supposed to deface this rifle that my grandpa gave me and write it with a Sharpie, a number? What am I supposed to do? Because there's no articulation in the statute as to what these people are supposed to do. And then at that point, even if you do put a serial number, again, what's the registration process? Where is this recorded? The whole point of serial numbers is in commerce, right? A manufacturer makes a firearm, puts a serial number on it. It goes to a person. The person then brings it into a gunsmith to get it fixed. They write it down. It goes through that chain. If an individual just scratches one in, what does that mean? What happens if that turns up at a crime or is stolen? How are they going to trace it? It doesn't solve any of the issues that are behind serial numbers because there's no explanation where there is a clear explanation in the federal law as to recording and how this all works.
You know, if we accept your argument that a criminal statute doesn't need to specify, not only needs to specify the nature of the crime, but also how a person can bring themselves into compliance with it, I mean, that would apply to many, many statutes in Minnesota, and I don't think we really have precedent that way.
So we're getting to the vagueness issue. Step 6. Yeah, let's talk about it. I agree, but as we've discussed, and I think we can all agree this morning, is this is a unique statute, and it is requiring action. So think about it in 1994 when it was written. We know that there were pre-1968 firearms without serial numbers. So it was telling people, you need to comply with this law. But there's nothing there for people to comply with. The only alternative would be you need to turn in your firearms. And as we've discussed, that would create huge Second Amendment issues. So I agree that it is compliance with the law, but it's asking what somebody how to comply with the law. It's not just ignorance of the law. It's saying, oh, I didn't know this existed. It's saying, I know it exists, but I don't know what to do about it, right?
But is there any precedent? Can you cite us to any case that says that simply because the statute doesn't specify how one complies, that it's vague under our constitutional framework? I
can't, and it's not because this court shouldn't rule that way. It's just that there hasn't been a statute like this that the way the states are. I mean, again, if you go to the legislative intent and we're talking about what is actually trying to do, it makes very clear sense of what's going on in the statute and what people need to do. If you take their interpretation, it creates this issue, right? Because like I said, in 1994, when the statute was written, there were these people that privately made firearms, people had firearms pre-1968, and there's no explanation as what to do. So I agree that there is not a single case.
Do people have any obligation whatsoever to investigate on how one might comply?
Okay, so if we take the state's interpretation of the statute and someone says, I have a 1967 rifle, how do I comply? Well, where would you look if the federal law doesn't apply? There's not anything in Minnesota law that would say you need to go to a gunsmith, you need to go to a licensed dealer, or, you know, the questions I've been getting is, should I be doing this myself? And again, if someone writes their initials and a number and then gives it to somebody else and then it's passed down the chain, how are we going to know what that is?
I guess I'm asking a slightly different question, which is, does a person have an obligation? Maybe there's nothing in the statute, but do you have any just independent obligation to call your local law enforcement and say, or something? Do you think people have an obligation to do that?
If the legislature passed a law banning something and didn't explain, it's just a mess. And I suppose you could, but I don't even know what law enforcement would say at that point, because they wouldn't have anything to look at either, because there's nothing that's prescribed in the statute.
Okay.
See, my time's up. I request it. Go.
Oh, I'm sorry.
Just quick, it's a similar question to the Chiefs. Do you have any authority on the grace period argument that you're making? Is there any authority that says that failure to provide for a grace period makes something void for vagueness or otherwise renders a statute ineffective.
No, but if I could just respond generally to that, I think the grace period argument also supports our argument that this is not a crime, right? Because in 1994, if the legislature truly wanted to create this, require this, they would have said, as the California legislature and the Connecticut legislature have recently done, we're going to give you until January 1st of 1996 to put these serial numbers on. Or if you're coming from out of state, we're going to give you 60 days to comply with this law, because that's fair and that's how due process works. So.
Thank you, counsel. Thank you to both of the attorneys here today for the help that you've provided to the court. We'll take the matter under advisement and we'll issue our opinion in due course.